Judgment in the appeals Al-Sirri and DD against the Secretary of State for the Home Department.
Lady Hale will give the judgment.
Both these appellants currently have leave to remain in this country. The question is whether they are also entitled to the status of refugee. Article 1FC of the 1951 Geneva Convention on the Status of Refugees excludes from that status, quote, any person with respect to whom there are serious reasons for considering that he has been guilty of acts contrary to the purposes and principles of the United Nations, end quote. Al-Sirri is an Egyptian who arrived here in 1994. He ran something called the Islamic Observation Center. The police found various books and videos relating to Islamic Jihad in Egypt and to Osama bin Laden and Al-Qaeda when they raided his premises. But the principal reason for denying him refugee status was his alleged complicity in the murder of General Massoud, leader of the Northern Alliance in Afghanistan, shortly before the atrocities of the 11th of September 2001, which he denies. The principal issue of law in his case is whether all activities which are defined as terrorism by the law of the United Kingdom are, for that reason alone, acts contrary to the purposes and principles of the United Nations, or whether such acts must also constitute a threat to international peace and security or to the peaceful relations between nations. DD is a citizen of Afghanistan who arrived here in 2007. One reason for denying him refugee status was that he claimed to have joined a military grouping, Hizb al-Islami, and commanded 10 to 15 people engaged in fighting against both the Afghan government and the United Nations mandated force supporting that government, the International Security Force, or ISAF. The principal issue in his case is whether armed insurrection is contrary to the purposes and principles of the United Nations if it is directed not only against the incumbent government, but also against a United Nations mandated force which supports it. A further issue in all such cases is what is meant by, quote, serious reasons for considering, end quote, a person to be guilty of the acts in question. This is particularly significant in Al-Sirri's case because he was prosecuted at the Old Bailey for complicity in the murder of General Massoud, but the judge dismissed the case on the basis that the evidence on which the prosecution relied was as consistent with his innocence as it was with his guilt. Both cases are to be returned to the tribunal to be determined in accordance with the guidance given by this court, in a joint judgment by Lady Hale and Lord Dyson, with which the other members of the court agree. The general approach to Article 1F is that it should be interpreted restrictively and applied with caution, because its effect is to deny the protection of refugee status to someone who would otherwise be entitled to it because he has a well-founded fear of persecution for a convention reason. As the guidance given by the United Nations High Commissioner for Refugees, UNHCR, states, there should be a high threshold, quote, defined in terms of the gravity of the act in question, the manner in which the act is organised, its international impact and long-term objectives, and the implications for international peace and security, end quote. There should also be serious reasons for considering that the person concerned bore individual responsibility for the acts of that character. The Court of Justice of the European Union has held that mere membership of an organisation which is responsible for such acts is not enough. It follows in the Al-Sirri case that it is not enough that the acts in question may fall within the definition of terrorism in United Kingdom law. The United Nations Security Council has declared that acts of terrorism are contrary to the purposes and principles of the United Nations, but the purposes of the United Nations, as set out in Article 1 of the Charter, are the preservation of international peace and security and the removal of threats to that peace. The UNHCR is therefore correct to say that the activity must have an international dimension. DD accepted that it would be contrary to the purposes and principles of the United Nations to fight against the United Nations assistance mission in Afghanistan. But he argued that fighting against ISAF was the same as fighting against an incumbent government, which is not prohibited by international law. But the court holds that the fundamental aims of ISAF accord with the first purpose of the United Nations, to maintain international peace and security, so that an attack on ISAF is in principle capable of being an act contrary to those purposes and principles. The court also makes some observations on the proper interpretation of the standard of proof required in Article 1F. The parties have 14 days to file their submissions as to the precise form of order